Good morning, afternoon, or evening. Your video is about to start. I wanted to remind you of our newer Wednesday, 1 p.m. live stream Q&A on all things Social Security. Visitors are welcome to post a question in the chat, and I'll do my best to answer it. It's on a first come, first serve basis, so please get there on time. Otherwise, if you care to be a member and get some different kinds of perks, feel free to click the join button below or just click it to learn about them. Anyway, I hope to see you Wednesday. If not, enjoy the video. Bye now. Hey all, so let's look at another circuit court case. This came out apparently in 2024, so not that long ago. And it happens to be in the Third Circuit, which is the one that I am physically in. Um, Probably at least half my cases are not in this, not in my neighborhood. But anyway, Third Circuit. And this is, it's very narrow, but I thought it was interesting. The summary is provided by a colleague of mine, Adriana, who does a stellar job summing up these circuit court cases for us, and I just appreciate it so much. She does a great job. It happens to be about a listing level 4.0 and cardiovascular impairments. So, listing levels can be tricky, right? They're very exacting oftentimes. I know a lot of people get the misconception that if I have an impairment that is called whatever is in the listing, then I meet a listing. And that's couldn't be further from the truth, unfortunately. So anyway, let's get to it. So it's about cardiovascular impairments and listing 4.00. So the case is called, I hope I don't butcher it, BISWAS versus Commissioner of Social Security. And I will say the claimant was denied and he did lose this appeal to the circuit court. But it's still worth noting because it helps maybe provide a little more detail as to what is needed when you're trying to prove a listing. And of course, a substantial evidence rule, it's still pretty powerful as a rule that gives ALJs their due discretion to make a decision as long as it's based on the substantial evidence. Doesn't have to be 100% provable anything, right? Okay, so Biswas was a former limousine driver, and he had gone through open heart surgery for an aortic valve replacement in 2001. He applied for SSD for a closed period. Now, just to refresh you, a closed period is when you were disabled with that 12-month durational minimum being met, and you were disabled as per the rules, found disabled, but then you improved. And a lot of people, it's not incredibly unusual for a person to definitively seek a closed period. They applied when they were, out, not working and disabled, but they were hoping to improve and in fact did improve and got to go back to work. But because they were out of work and disabled for at least 12 months, they were able to prevail on a closed period of disability. And it would end generally when their medical records say they could go back to some sort of job, remember, some sort of job, not necessarily the one they had, or they did in fact just go back, regardless of what the medicals say. As long as it was SGA work, of a certain particular level of earnings. In any event, the ALJ apparently had acknowledged that he had severe impairments, of course, including that status post-aortic valve replacement and as well as peripheral vascular disease, but he determined that they didn't meet or equal a listed impairment under the Social Security regulations. The Third Circuit did uphold the denial of benefits and was relying on the substantial evidence supporting the ALJ's decision. So Adriana shares with us that the primary focus in this case was whether he met or equaled the listing. So this wasn't even about substantial evidence to prove his RFC, could or could not allow him to do any other jobs, nothing like that. All about the listing. That's the major point here. So I don't see these too often. They pointed out that the listing requires, this is the cardiovascular listing, objective medical evidence such as ECGs, stress tests, or imaging, and they must demonstrate the severity of the impairment. Specific criteria such as persistent symptoms despite treatment, functional limitations, or certain test thresholds must be satisfied as well. The ALJ's analysis had included this. He reviewed BISWAS, claimant BISWAS's medical records, which included evaluations by a couple of doctors. And while the claimant reported symptoms of fatigue and shortness of breath and chest discomfort, the ALJ highlighted certain things when denying him. The EKG and imaging results, these tests didn't show findings consistent with listing level severity. So you really have to go, and I pointed this out to people, you almost have to go through your medical records and literally draw a line from, like, when you look at the listing, you're not going to draw a line, but I would be saying Dr. Jones' treatment record of 2/1/25 states this. And if that actually covers exactly what's in that listing, because there's going to be a bunch of criteria in the listing. So you want to have the source of where you believe that particular piece of the listing has been met by which particular line or lines in your medical evidence file. Okay. The judge also pointed out that something about examination findings. Both the doctors had observed mild cardiomegaly, but found no signs of congestive heart failure. And I'm sure I butchered that word. Murmurs or severe functional limitations. And by the way, the severe functional limitations, if they didn't find the severe functional limitations, that's probably why this wasn't going to be an RFC case. It was either going to be a listing or not at all, is my guess. And again, Adriana did all the reading. I'm just enjoying her summary. He also went to residual capacity. The one doctor concluded that the claimant could perform basic activities such as sitting, standing, and walking with some limitations for exertion-heavy tasks, which, that's kind of to be expected. Exertion-heavy tasks when you've had very significant cardiovascular events like this fellow, but you're still not getting to the sitting kind of jobs, the sedentary jobs, the light jobs. So that's why the listing level and meeting it was so important. The court's conclusion was that, and this is the Third Circuit again, found that the ALJ had explained why the claimant's medical evidence fell short of a listing level severity. The consistency of medical opinions reinforced the conclusion that his impairments, though severe, did not rise to the threshold necessary for an automatic finding of disability. And that's what the listings are really about. It is like you're automatically disabled, even if you're doing backflips in your backyard, if your medical records show that each and every requirement in that listing is met. You can be doing those backflips in your backyard, okay? But if the listing is met and it's technical. It's somewhat black and white, although of course, different ALJs might have different thresholds of what they think tips over into severe and not severe in terms of severe enough to meet a listing. But they do have those guidelines of the somewhat black and white rules that a lot of these listings have. So that's about it for listings. And I bring it up because a lot of people say to me, but I made a listing. I made like 5 listings. And I'm like, well, no, you think you do, but have you gone through and connected those dots and made a list of, each and every line in your records that proves, the 3 things that you had to prove under Part A, and then the 2 things you had to prove under Part B, or did you jump to Part C if you could do an either or? I mean, there's no presumptions. You have to point to the evidence. And I always say most people don't win on a listing. If they do, they're going to win on the initial, probably. But yeah, listings, I don't find to be the heavy. Those would honestly be the easy cases, and I just don't get enough of them. So it tends to be the long haul of work, proving that RFC and the observations of doctors and the function report, which can be, as we always say, you're not so much going to win on your function report, but you're going to you don't want it to be the cause of you losing on initial recon or at an ALJ. And an ALJ will cite to things you said in your function report a couple years ago if they are consistent with the medical records that he's finding to be credible. So, and all it does is help strengthen your case and perhaps reduce the possibility of an audit and an overturn. So anyway, BISWAS versus Commissioner of Social Security. Super duper. Thank you so much, Adriana. I much appreciate it. And I hope you guys have a great night, and I will see you next time. Bye now.